If you're here for the land surveyor talk, that's down the hall in wing room 118. Please remember to turn off your cell phones. The parking validation machine for the garage under City Hall is located at the rear of the chambers. Following roll call during summary of hearing procedure, we'll review how the public may provide comment during today's session. At this time, we'll do the Pledge of Allegiance. Thank you. Now we'll take roll. I'm Justin Lardwa. I'm here. Vice Chair Nellis Wise.
Here.
Commissioner Barosio.
Here.
Commissioner Bickford.
Here.
Commissioner Cantrell.
Here.
Commissioner Casey.
Here.
Commissioner Garcia.
Here.
Commissioner Oliverio is absent. Commissioner Rosario, I see you walking up. Commissioner Tordillos.
Here.
And Commissioner Young.
Here.
I believe that's 10 in attendance. Okay. Great, we have quorum. All right, summary of hearing procedures. If you want to address the commission, please fill out a speaker card located on the table near the audiovisual technician and deposit the completed card in the basket. There will also be speaker cards in the back of the chambers and at the side entrance. The procedure for this hearing is as follows. After staff's presentation, applicants and/or appellants may make up to a 5-minute presentation. During the public comment period, the chair will call out names on the submitted speaker card in the order received for those members of the public who attend in person. As your name is called, line up in front of the microphone at the front of the chamber. Generally, each speaker will be given up to 2 minutes for public testimony, and speakers using a translator will have up to 4 minutes. At the discretion of the chair, the time allotted to each speaker may be changed depending on the number of items on the agenda, number of speakers, and other factors. Speakers using a translator will have double the time allotted. After the public testimony, the applicant and/or appellant may make closing remarks for up to an additional 5 minutes. Planning commissioners may ask questions of the speakers. Response to commissioner questions will not reduce the speaker's time allowance. The public hearing will then be closed, and the Planning Commission will take action on the item. The Planning Commission may request staff to respond to the public testimony, ask staff questions, and discuss the item. If you challenge these land use decisions in court, you may be limited to raising only those issues you or someone else raised at this public hearing or in written correspondence with the city, written correspondence delivered to the city at or prior to the public hearing. The Planning Commission's actions on rezonings, pre-zonings, and general plan amendments and code amendments is only advisory to the City Council. The City Council will hold public hearings on these items. Section 20.1, 20.400 of the Municipal Code provides the procedures for legal protests to the City Council on rezonings and pre-zonings. The Planning Commission's action on conditional use permits is appealable to the City Council in accordance with Section 20.100.220 of the Municipal Code. Agendas and all staff reports for this meeting may be accessed at the city's website. I'm off my game tonight. Let's see. Call to order and orders of the day. Before we begin, I want to remind the Planning Commission members and members of the public to follow our code of conduct at meetings. This includes commenting on the specific agenda item only and addressing the full body. Public speakers will not engage in a conversation with the commissioners or staff. All members of the Planning Commission, staff, and the public are expected to refrain from abusive language. Repeated failure to comply with the code of conduct, which will disturb, disrupt, or impede the orderly conduct of this meeting, may result in removal from this meeting. This meeting of the Planning Commission will now come to order. We'll move on to public comment. This is a time for public comments to the Planning Commission on non-agendized items. Please fill out a speaker's card and give it to the technician. Each member of the public may address the commission for up to 2 minutes. The commission cannot take any formal action without the item being properly noticed and placed on an agenda. In response to public comment, the Planning Commission is limited to the following options: responding to statements made or questions posed by members of the public, or requesting staff to report back on a matter at a subsequent meeting, or directing staff to place the item on a future agenda. And I'll note that at this time, the city is only accepting public comment in person here in the chambers. Do we have any members of the public who would like to give comment on items not on tonight's agenda? I don't have any cards and I don't see anybody standing up, so I'll take that as a no. For deferrals and removals from calendar, I believe we have nothing. Is that correct? Okay, so we'll move on to the consent calendar. Notice to the public, there will be no separate discussion of individual consent calendar items, as they are considered to be routine and will be adopted by one motion. If a member of the commission requests debate, separate vote, or recusal on a particular item, that item may be removed by the consent calendar by the chair and considered separately. The public may comment on the entire consent calendar and any items removed from the consent calendar by the chair. Staff will provide an update on the consent calendar. If you wish to speak on one of these items individually, please come to the podium at this time. And on tonight's consent calendar, we have item A, which is our minutes from our May 8th meeting, and item B, which is the vacation of an easement on Hillsdale Avenue. Do we have any members of the public who'd like to speak on either of those items? And if not, do we have any discussion or motion from the commission?
Motion to approve.
Second.
Okay, I don't see any members of the public who want to speak, so I'll recognize the motion from Commissioner Casey to approve the consent calendar and the second from Commissioner Tordios. If there's no further discussion, I'll take us to a vote. Are we just getting ready to vote? Okay, Vice Chair Ellis-Wise?
Yes.
All right, Commissioner Borosio?
Yes.
Commissioner Bickford?
Yes.
Commissioner Cantrell?
Yes.
Commissioner Casey?
Yes.
Commissioner Garcia?
Yes.
Commissioner Oliveira was absent. Commissioner Rosario?
Yes.
Commissioner Tordios?
Yes.
Commissioner Young?
Yes.
And myself, yes. That's 10 in favor and 1 absent, so it passes. Okay, we'll continue on to public hearing. We have 3 items on our public hearing tonight. The first is item A, PP 23-07, which is a number of changes to the municipal codes. I'll just leave it to the staff presentation to summarize it because it's quite a few unrelated things. So you can go right ahead.
Thank you, Chair. Item 5A is file number PP 23007. It's a proposed zoning ordinance update related to ADU condominiums, a new enumerated use within downtown, minor edits to residential development standards, bicycle parking, and permanent supportive housing. Staff routinely updates the zoning code to incorporate changes to align with new state law mandates and other requirements. The proposed update incorporates changes to conform with current state mandates and to follow direction from our City Council. There was no specific development proposal that initiated or were part of these changes. Here are the items proposed for this update. To begin, we are introducing a new section in our zoning ordinance to allow the sale of ADUs as condominiums in accordance with recent State Assembly Bill 1033. This is followed by more routine updates, including some updates to our single-family residential development standards. We are allowing indoor sale of zero-emission vehicles in the downtown zoning district. We are reinserting text related to bicycle parking requirements inadvertently omitted in the previous parking code update. And lastly, we'll incorporate minor edits to the definition of permanent supportive housing code to align with state law.
I just want to note that Commissioner Oliveira has joined us.
First item is ADU condominiums. AB 1033 was effective in January of 2024 to allow sale of ADUs as a condominium. The zoning code does not currently allow the sale of ADUs separate from the primary dwelling they are associated with. During a December 2023 hearing, we received direction from City Council to explore options in implementing AB 1033. As far as we know, we will be the first city in California to have an ordinance to allow for ADU condominiums. Staff is finalizing planning process to review these conversions. If approved, this would involve a parcel map process for our Public Works Department. We have a similar process already in place for SB 9 projects. Per AB 1033, state law mandates that the primary requirement for every ADU condo project is in conformance with the Davis-Sterling Act for the formation and maintenance of common interest developments. It provides HOAs with authority to develop CC&Rs and regulate their maintenance, repair, and replacement of common areas. This is a list of mandatory submittal requirements that staff has identified, including an application checklist, title deed, ADU permit issuance, lien holder approval, notification of utility companies for condoization, fire code compliance for separation of units, and a building final permit, HOA formulation, condominium plan including all common areas, a detailed site plan or boundary map, and this will be an entirely administrative process with no public hearing. Moving on to our next section of the update, we are making some minor edits to our single-family residential code section. These are clarifying changes that would benefit homeowners. Number one, we are clarifying that walkways and landings that do not exceed 2 feet in height will be allowed within side setbacks. In the current zoning code, nothing is allowed in side setback, including necessary landings for door openings or concrete steps for sloped lots. Retaining walls are proposed to be allowed in the front and corner side setbacks. Our current code requires a development permit to construct necessary retaining walls. We will also clarify that overhangs that do not extend more than 2 feet from the structure or building will not be counted towards rear yard coverage. This will provide a larger allowance and more clarity and consistency during project reviews. The use of indoor sales of zero-emission vehicles will be added to our downtown zoning districts. This proposed change and use is consistent with general plan designation and policies, and this would help attract clean energy businesses to the downtown zoning districts. Vehicle sales is allowed in other commercial districts, and the indoor use aspect would be non-disruptive to city streets and other circulation. For bicycle parking, we're talking about the bicycle parking ratio requirements for multifamily residential development. This was an oversight that this portion of the code was taken out when we did our major parking ordinance overhaul a year ago. This update is simply to reinsert the omitted text. For this item, we're making minor updates in 2 areas. First, we're updating the zoning code to include recent references to California government code sections for permanent supportive housing. More specifically, to reference the state supportive housing law, state low barrier navigation centers law, state streamlined ministerial approval process, and the section for affordable housing. And the last item we're updating is the definition of permanent supportive housing to align with the state. The reworded definition will consider properties with at least 25% of units dedicated to supportive housing as a permanent supportive housing project. The remainder of units will be dedicated to deed-restricted units. This definition will align with the state's definition. So next up in the timeline for this code update will be City Council hearing scheduled for June 11th. If approved, this ordinance will be effective sometime in late July. Staff wanted to also note 2 recent changes in the ordinance. The ADU condominium section. Number 1, state law section number references will be revised in the final ordinance draft. A recent state law update has modified existing numbering, and this city ordinance will be updated accordingly. Number 2, we got some recent feedback from some of our stakeholders, and we made some edits to our required CC&R section in the draft ordinance. We added as applicable as seen in the modified ordinance sheets. These items aren't necessary in some HOA formations. This is the end of staff's presentation. Thank you for your consideration.
Thank you. We'll go to public comment at this time. I have a card from Seth King, so you'll go first. And if anyone else would like to speak on this item, feel free to line up behind him. You'll have 2 minutes, and then the mic will turn off automatically after that.
Great. Thank you, Mr. Chair, members of the Planning Commission. My name is Seth King. I'm Managing Counsel for Global Zoning, Land Use, and Licensing at Lucid Motors. And if you don't know Lucid, we're an electric vehicle manufacturer. We're just based right around the corner in Newark, California. We have a direct-to-consumer business model where we sell our cars directly to consumers. We don't work through dealers. And we have over 22 studios here in North America and 19 service and delivery locations, and including several here in the Bay Area. We have additional locations over in Europe and the Middle East. We produce the award-winning Lucid Air sports sedan, and we've got an SUV that's in pre-production stages. Speaking to you now to address the text amendment allowing sales of zero-emission vehicles in the downtown area. I think that it was Lucid's outreach to the Office of Economic Development that triggered this amendment, and we're very supportive. We're very appreciative of the city in bringing it forward. I am here to request an amendment to what's before you. The proposal before you includes a note 3 below the use chart, and that limits the use to no outdoor storage of new car inventory. And Lucid is considering a site in the downtown area, where we would like to be able to, and it would be part of our business plan to be able to engage in outdoor storage of new car inventory there. It would just be a small number, perhaps about 15. We're willing to propose conditions to that, such as that the new car inventory be screened or that it be set back so that it doesn't extend in front of the building. And so we would ask that the Planning Commission approve the text amendment, but that it modify it to include a change here to allow this limited outdoor storage of new car inventory. We have reached out to city staff, and they have been very good to work with. We've had some discussions here, but have not been able to.
That concludes your time. Thank you very much. Do we have any other members of the public that would like to speak on this? If not, I'll turn it over to the commission. Commissioner Tordias.
Thank you, Chair. I wanted to say that I was very excited to see the ordinance enabling separate sale of ADUs over the past couple of months as we've, processed the mobile home land use designation. We heard from many residents who spoke to the fact that there just are not many opportunities for lower cost home purchases in the city of San Jose. I think this could be a great tool to add to our toolbox to add more lower cost home purchase options specifically, while also moving the needle on a number of important general plan goals like mixed income communities, the ability of seniors to age in place, multi-generational living, and also just want to acknowledge the fact that this really did come together quite quickly. AB 1033 was only passed last year, so huge commendation to City Council for moving so swiftly to embrace these new tools from the state, and a big thanks to staff for the quick work on the enabling ordinance. I did have one question on the bicycle parking clerical fixes. I think in the staff report and in the presentation that we just saw, it listed the ratio as 60% short-term, 40% long-term, whereas I think in the draft resolution that's inverted. So I was just curious which was the correct ratio.
Nothing gets by you.
Just 1 second while we scroll to that section.
Thank you, Commission. It's 60% long-term and 40% short-term.
Thank you for the clarification. That was my only question. Thank you.
Thanks. So I might have seen Commissioner Oliverio and then Commissioner Cantrell.
I withdrew it because I wasn't sure I hit the right button, but
Okay.
I did have a comment.
Yeah, go right ahead.
Great. So really, outside of the state ones where state legislation is telling cities to go do this, really the only local ones are the one that Tordios mentioned, which had to do with the mobile home, the side setback 2-foot patio or entrance step, the bike ratio, and then the car sales. Is that correct? Everything else was sort of state legislation?
Thank you, Commissioner. Martina Davis, Division Manager. Yes, I would say the only other one would be the permanent supportive housing. We don't have to align our definition with that. However, we felt that it was beneficial to just have a common definition with the state on how we define that use.
That'd be similar to matching the state building code or something.
Correct.
Great. And then the gentleman from Lucid who, so I was very familiar with when we allowed Tesla to go at Santana Row, and they have some outside car storage there as well as a couple cars on the inside. How does staff feel about the suggestion from them?
I would say we have, some trepidation about outdoor car sales in an urban setting downtown. That said, should the commission, think that that is something that the council should adopt, we would recommend some standards around that, around setbacks, screening, and limiting size. So if that was the commission's recommendation, that's what we would recommend move forward.
And the level of concern is when it's not beautiful green cars and that they're used clunky cars, and the distinction?
Yes, that more so when you have vehicle inventory storage, it tends to be in fenced areas for security reasons. It tends to look more like storage, you
Right.
know? So it's kind of, do we want to walk downtown? Concern, is people going to start turning the parking lots into kind of vehicle storage lots behind a fence? So again, there could be ways to mitigate that, right? With screening, with setbacks, with size limitations, but that's the concern.
Yeah, and particular to this, I don't think, their location is not like on Santa Clara Street. It's on the periphery of the downtown and has some more land than a storefront, is that correct?
Yeah, I believe they're looking at a site on Stockton that is on the periphery of downtown, so there's a surface parking lot there already. And in their case, they would have plenty of space to set it back.
Okay. Yeah, I would certainly be interested in staff trying to, look at the accommodation of that, and in between this and the council meeting, come back with, hey, this is what was asked. We're trying to do economic development here while people aren't in the downtown. So anything is a good thing, especially with, I think Lucid's a good brand, and et cetera. So that's my thoughts. I won't make a motion at this point unless someone wants me to, but I'd rather let everyone else speak. Thank you.
And we certainly could work with them and any other stakeholders to come up with some conditions for council.
Thank you very much.
Commissioner Cantrell.
Actually, I did have a question about the the cars as well. I'm curious, what would be the delivery model for someone buying a car if when that car comes in, is it just shipped to their home, or would they be able to pick it up at the dealership? And if so, how would you facilitate that if they couldn't store them there? I guess that could be for the...
I'll leave it up to staff or Mr. King, whoever wants to
Yeah,
answer.
I can take a stab. My presumption is if they want on-site inventory, that people would pick up the cars from there. I know, for example, the Tesla model, generally speaking, the inventory on-site is not the inventory that people purchase. The car is delivered from the factory to their home, right? So they go test drive the car, but it's not that's not the car they buy. It does sound like, if they want on-site inventory, my presumption would be the customer would pick up the car from there. So if it wasn't allowed, they would be allowed to have indoor on-site inventory, right? So if in a larger building, you can park cars indoors. If we didn't allow outdoor, right, that would limit how much they could have on-site, and they would have to look more at the delivery model from this location.
And then part two would be, I wouldn't buy a car I couldn't test drive. So how do they facilitate that?
Again, we're anticipating a indoor kind of model. The other thing is, they do have a parking lot, and there's a question of, are you parking a test drive car there? That's why we really restricted it to vehicle inventory storage, so that there was a little bit more flexibility around the cars that are being test driven. We can get that inventory. That's your test drive car. That's kind of why we chose that word, is we're really more concerned about this sort of less active storage area than the more active test drive cars.
Actually, all cars on the lot are in inventory. They sell the cars that are test driven too.
Yeah, fair enough.
Okay. One other quick question, just curiosity. I was noticing on the ability to put walkways and decks on the side of the house, which is, I think is kind of cool. What's the setback that's required for that?
There's no setback for deck or walkways, but they're limited in height up to 2 feet from grade. So you can build all the way to your property line.
Wow, okay, thank you.
Vice Chair Ornelas Wise, and then Commissioner Young.
Great job, staff, on making all these changes to the ordinance. I know it's a lot of work, so I commend you for that. I would like to see, I think it's fantastic with the ADU, and I agree with my colleagues. We obviously want to see more affordable homeownership opportunities in the city of San Jose. I, of course, would like to see those projects, because it seems like it's a lot of stuff with the CCNRs and a lot of the legality involved to somehow streamline those. I don't know if you could have like express for ADUs, I don't know. And I think once you figure it out for one, help streamline those as they come in. I think that would be nice to do if possible. In regards to the rear lot coverage, I didn't see the ordinance specifically, but I know what I've seen in other cities, they usually have a really nice diagram, and sometimes that makes it really easy when someone's looking and sees, okay, I get it real quick. I didn't know if you included a diagram with that.
Respond to that. So historically, we have not included diagrams in the zoning code. Historically, that has actually been on the advice of legal counsel. That said, we do have diagrams on our website because, yeah, a picture is worth 1,000 words. So, you know, I do believe we have a rear yard coverage one. I used to work the counter. I'd hand it out all day, every day when we did paper forms. So we'll be updating it for that clarification. But yes, we do use visuals for that kind of thing.
Okay, great. And I do think that depending on the location of the downtown, that maybe having, you know, a few cars on site might be okay. But I think as we go closer to the city center, it might not be appropriate, you know, because of safety reasons and like some of the things that you mentioned. I agree with that. But I think if it's a little bit on the outskirts of the downtown and there's some more room and not so much traffic like in the core of the downtown, I think it would be okay to allow some parking on site for the vehicles. All right, great job.
Commissioner Young?
Thank you, Chair. Question for staff on the request from Lucid, kind of a process question. When did Lucid come to you all and request this amendment? How long ago?
So we have been talking to Lucid for some time. The inventory storage came up pretty recently, that specific inventory issue, but we have talked to them about the project for some time. I think just that one little nuance has come up within the last day or so.
Okay, just to clarify my question, when did they request the outdoor storage as well? How long ago?
So for the outdoor inventory storage, today for myself, prior we had talked about, what did we talk about prior, Aparna, for outdoors?
We did review the sale component of it, and I think the outdoor storage as an inventory came up very recently.
So you've been working with Lucid for some time on the indoor storage, but the request for the outdoor storage came up pretty recently. Is that correct?
Yeah, we've been working with them more so on, you know, if you notice, it prohibits outdoor sales, and so we kind of talked to them more generally about outdoor uses, but that specific nuance around inventory storage and that restriction on inventory storage did come up today.
Okay. I have concern with the amendment, and it's similar to what Commissioner Ornelas-Wise mentioned. I think if we approve an amendment like this, we're improving it for the entire downtown. We don't have the ability to, you know, specify where it's going to be. So I don't particularly think that downtown Santa Clara Street near City Hall would be a good place to have basically a building with a car lot outside. Now let me say I'm completely supportive of Lucid. I'm completely supportive of EV and green vehicles. But I think on this commission, we have to be careful of precedents that we set. So I would not be able to vote in favor of the amendment. I would rather, let me ask one more process question. So if we were just to approve the staff recommendations without any amendment, this is going to go to City Council, correct? Okay. So if Lucid wanted to request an amendment from the City Council, thereby giving you all some more time to work with them, that would be a possibility, correct?
Yes.
Okay. Well, with that in mind, I think I'm not in favor of this commission approving that amendment at this time. I think it would be more appropriate to let staff have more time to work on it and let the council make the decision. Thank you.
And I'll just note that there's currently no motion on the table, that any amendment is hypothetical at this point. Commissioner Barroso and then Commissioner Cantrell and then maybe Oliverio again? I don't know if that's intentional or not.
I'll pass for the moment in case somebody wants to talk about the parking. I want to talk about the ADUs.
Up to you.
Yeah, I'll pass.
Okay, Commissioner Cantrell?
Actually, I'm curious if we pass it as it is and they want to pursue some sort of exemption themselves during their permitting process, isn't that a possibility?
As the way the code is written now, it's just prohibited, so there wouldn't be a path for them to be able to get an exception or have any site-specific analysis.
Okay, thank you.
Commissioner Oliverio and then Commissioner Barroso?
Thank you, Chair. And I come up on your list when I hit this button, is that correct? Or are you just looking by the light?
I look by I have two lists. I'm not sure which button is which. I just kind of go on wherever order they come up.
Yeah, so I'm looking at Santana Row right now in Tesla on Google Maps, and they have 9 outside parked cars. So, they want 15, Tesla has 9. I'm not telling staff that you have to go do it. My suggestion is, this has been brought up, it's key to economic development. Let's look past the item tonight, meaning all the items, and within there is also direction to simply look at it, work on it. So by the time you get to council, then you've had that discussion on what could work, what would work. Here are the options, city council, this and that. I do think, even allowing things in the downtown core, you could also say must have a certain square footage or lot size, because you're not going to get that in the downtown. And I think even car sales in the downtown, you go on Van Ness in San Francisco, they have cars there and they store them. And I know the city historically has issues with cars parked. I'll tell you a quick story. Somewhere in the city of San Jose was someone who had an auto shop, and they did work on high-end Ferraris and all these great cars. And they parked them on the street, and then someone called saying, hey, you're parking these cars on the street. So the gentleman leases a warehouse around the corner and parks the cars there. And then the city popped him for parking the cars within an area that he had leased because he didn't have the permission to store a car, which was a car that was being worked on. So inevitably, it's difficult to try to please everybody, but I know this is a topic that's been up there. All I'm saying is, and I'll make the motion, that we approve the staff recommendation with the intent that staff would have some conversations with Lucid, see what they can come up with, and present that to the city council, and then the city council's making that recommendation. I wouldn't want to just say, let's approve the staff recommendation and leave that off the table. I think we've heard the concern. We all want economic prosperity in the city, which comes through sales tax and all that, to pay for city services. It's just being open to the thought, that's all.
I'll second.
Could I ask you to state that more succinctly?
Good Lord. No, let's approve the agendized item with direction to professional staff to work with Lucid to see what are the options and to bring those forward with this item to city council, and they make the decision.
Okay, so there's a...
Is that, I could probably try to cut it down again.
That works for me.
Okay.
Does that work for you, Daniel? All right, attorney approved. So we have a motion from Commissioner Oliverio and a second from Commissioner Cantrell. There's still some hands up, so we'll continue discussion. So maybe Commissioner Barroso and then Commissioner Young.
Mine's around the ADU. Is yours around the parking, Commissioner Young? I just don't want to break the flow of the conversation, so I'll go when the parking stuff is out of the way.
Okay, Commissioner Young?
So with respect to Commissioner Oliverio, Santana Row is not anything like downtown. It's a privately owned shopping center. Maybe you can call it a shopping center, but it's privately owned, it's privately developed. They can do whatever they want there. If they want to have cars outside, that's great. I think downtown is different. I think that for our commission to make that recommendation that staff explore it indicates the support by this commission for that concept. So I'm going to make a substitute motion that we approve the staff recommendation as written.
Second.
Okay, we have a motion from Commissioner Young to substitute Commissioner Oliveria's motion with just approving the staff recommendation, and a second from Commissioner Tordios. Okay, we'll continue discussion. Excuse me. Commissioner Casey, and then, yeah, we'll go from there.
This location is on Stockton. I'm assuming it's right across from the Whole Foods. I don't necessarily designate it as the downtown core, and I don't see that as traditionally being considered downtown. Is there any way that we could restrict this amendment to a certain core area where Commissioner Young mentioned it would be unsightly to have this type of development, whereas outside of the downtown core it'd be more appropriate or less offensive, and on a Stockton or something similar to that?
Yeah, absolutely. You could have different geographic standards within downtown. We actually have some precedent for that. For example, we have the downtown ground floor overlay where we require more active uses along certain streets downtown. So there's definitely precedent for treating different parts of downtown differently. So that is something that could be done.
Given that opportunity, I think that's possibly the best of both worlds. And would Commissioner Young be amenable to something along those lines where we would preserve the sanctity of the downtown core? And the example you gave, for example, across the street from City Hall, we wouldn't have to endure or consider any of those types of projects, but where it's more appropriate outside the downtown core. Because again, I've never considered that portion on Stockton to be part of downtown. And so the idea that it would be subsumed by this policy, I don't know, just food for thought.
Commissioner Young.
So what would be the process of doing that?
So we would work with Lucid and do some analysis and come up with a recommendation for council on a geographic restriction for the outdoor uses. And we would like to look at some other things too, again, as potentially screening and setbacks as well.
Okay, so that would take place independently of whatever this commission recommends, correct?
Yes, so the commission could give us direction on where you want it to go. So you could tell us areas that you for sure want not to be included, for example, but or you could give more general direction to look at geographic exclusions, up to what the commission, how much detail recommendation you want to give to us.
Okay. So with that in mind, no, I would not be in support of your suggestion, Commissioner Casey. I have a difficult time making large citywide decisions based on a request from a single company. I mean, I had no idea where they're planning to do this. Apparently, some of the other ones of you do. I just don't think it's appropriate for us to amend a staff recommendation for a single company in a single location, because what's going to happen is then other car companies are going to come in and want that same exemption. And I don't think it's appropriate for this commission to do that. If Lucid wants to explore an exemption, I think that they should work with staff, and then that recommendation should go to council. I'm not comfortable doing it at this level.
I just want to, before I call on more folks, just note that we're an advisory body making a recommendation here. I think there's been some discussion about like the specific site or like specific restrictions. In my view, it makes the most sense to either make a recommendation that staff explore outdoor sales and relevant conditions around that, or not. I don't think specific details are really appropriate for us to engage in. That's just my opinion. But given that, I just want to continue the discussion here. I've got, I believe it was the orders Tordios, Bickford, and then Oliverio.
Thank you. Yeah, for this specific site under consideration here, I don't actually have concerns about outdoor storage or sales. I think I'm inclined to agree with Commissioner Young that for me this is really about trying to be overly prescriptive, kind of on the spot here as an advisory body, drawing these lines about where this is and is not allowed. I think I would feel most comfortable with moving forward approving the staff recommendation as written, with the understanding that staff will, separate from our recommendation today, continue to engage with Lucid and potentially bring an updated proposal to City Council that does have some more nuance here to allow the Stockton site to move forward.
Bickford and then Oliverio.
Thank you. I believe I heard a few minutes ago staff say that accepting this as is would leave no recourse for Lucid to make a future or additional request for outdoor parking. Is that the correct interpretation of what staff said?
So it's, if this ordinance is adopted as is, they wouldn't have a permit path to ask for outdoor inventory storage. What I will say is if the Planning Commission adopts the recommendation to recommend council to adopt per the staff recommendation, council still can adopt something different, right? So they still would have an opportunity to speak to council before the council hearing and say, hey, can you adopt a different ordinance? So that would be their path to do that between them. But if council does adopt the ordinance per staff's recommendation, that's the end of the line for them.
So with my understanding of what she just said, I don't believe it's in our best interest to just accept the motion as is without stating that we think that there should be recourse, whether it's Lucid or anybody else, for opportunities in the downtown area, because it's not just going to be this. There are other things that we need in the downtown area that might not be ordinanced, and how do we leave the door open for that if we're recommending something that closes the door? I'm having a hard time with that. So I understand what you said, and I believe one of our responsibilities is to leave doors open, not to close them, or not to recommend that they be closed.
Just to clarify though, currently auto sales just aren't allowed downtown at all, right? Indoor or outdoor?
Indoor vehicle sales of vehicles of less than 1,000 tons are currently allowed, so that's essentially motorcycles and Vespas.
Right, but
1,000 pounds, not tons.
But this ordinance change is expanding it to indoor sales of all vehicle types.
Right, clean air vehicles,
Oh,
but yes.
sorry.
Yeah.
Thank you. Just want to clarify that. All right, Commissioner Oliverio and then Vice Chair Nellis Wise, and I'll make sure to not forget about you, Commissioner Brosio.
Okay. So often what happens is the Office of Economic Development is trying to lure a business to the city of San Jose. And in their due diligence, they find an ordinance that doesn't work for them. It doesn't work for the prospective client. So OED comes to planning or comes to the mayor's office, they go somewhere and they say, we got to change this if we want to get this client. And this has been done all the time for all sorts of companies to get them to happen, because one size doesn't fit all, so they make a little bit of a different change so they could accommodate it. So that's why we're here, and I'm sure if OED was here, they would be interested in continuing the conversation. And no, even though Santana Row is private property, they couldn't do what they wanted to do unless they got the city to change the rule. And so that was for them to have the use at Santana Row to sell cars, and then they wanted the outside cars, and they had to get that permission. So it's one of these things that cities will accommodate based on the request. They don't have to, but they chose to in the past for Tesla. And I'm just, back to my point is, there should be a conversation, because OED's involved in here. There's a prospective client, and we have an ordinance, and let them have a conversation. That's all. And we'll see what comes up with that conversation. But I don't want to, what Commissioner Bickford said, to just pass us on with as is based on what we know now. That's all.
Vice Chair Nellis Wise and then Commissioner Tordios.
This Sunday, I walked downtown with my little girls. I have a 6-year-old and a 9-year-old, and I used to walk downtown a lot when I was a little girl with my dad. He loves San Jose, and he helped me learn to love San Jose too. And I saw so many vacancies and so much blight downtown, and because I love the city of San Jose, I think we can and should do whatever we can in our power and through the ordinance, because there's a lot of red tape in the zoning ordinance, right? To allow the flexibility, to allow more business. Yeah, so, and I think that city staff can condition it in a way when these projects come in to screen, to, make it safe so that there is some neighborhood compatibility. Just because I hadn't walked downtown for a while, and it was on a Sunday afternoon with my kids. And I think that whatever we can do, as some of the commissioners have mentioned, I thought about, can we see the map of the downtown ground floor retail? But that might have been what I walked. And I think that's the core that I think requires a little bit more revitalization. Therefore, I do think that we should have, do whatever we can to make it more flexible, to attract more business to the city of San Jose, to the downtown. Those are my comments.
Thank you. Commissioner Tordios?
Thank you. So there's a lot of discussion here about, closing doors, cutting off conversations. So I just wanted to clarify with staff, if the commission does move forward with adopting the staff recommendation as written, does that mean that you just kind of stop talking to Lucid and do not further engage on this question of outdoor inventory storage, or will those discussions continue to happen even if we adopt the staff recommendation as currently written?
Frankly, I fully expect them to, have the same comments for council, which means that regardless, I do believe these conversations will continue. Because if council is interested in having outdoor storage, we will need to come up with some language and conditions around that. So I think it's likely that regardless, this conversation with Lucid will continue.
Thank you. Again, I agree that there may be sites within what is technically downtown where this sort of use should be encouraged and allowed. I really do just come back to Commissioner Young's comments of not wanting our approval or amendment of the staff recommendation to be perceived as saying, I actually do want car lots on Santa Clara Street. So that's kind of where I'm coming from on this.
I saw Commissioner Cantrell's hand go up. Okay. Okay, well, I think we've exhausted this discussion. I just want to say one more thing, and then we'll go to Commissioner Borosio to discuss, a non-auto sale issue. So I broadly agree with everything that my colleagues have said tonight. I don't want to turn Santa Clara Street into Stevens Creek Boulevard. But at the same time, I recognize that there is a need for economic development in the city of San Jose. Jobs, housing, and balance, revenue streams, all really important, and especially downtown where we do have a lot of commercial vacancy. And I also just want to say, from the answers we got from staff in response to our questions, I have a lot of trust that they have the right concerns here about what potential problems could arise if outdoor sales are allowed downtown. And so I think, they're going to approach this from the right frame of mind. So personally, I'm in favor of Commissioner Alvario's motion. I think it's totally reasonable to add that to our recommendation. But that's where I'm at. I think if you don't mind, Commissioner Young, hopping in front of you, Commissioner Borosio. Yeah, go right ahead.
Not to belabor the point, but I have a question for our attorney. Is it possible to remove this particular sub-item so that we can vote on it separately? And the reason I say that is I'm in support of everything else in this staff recommendation, and I would personally hate to vote against it because of my concern on this one little piece. So is it possible to separate it?
So does Rosenberg's rules allow us to divide the question?
Yeah, I mean, let me think about this for a second.
Okay. We'll turn over to Commissioner Borosio then, while you...
Sure. Yeah,
Okay.
that's great.
Perfect. Thank you, everyone. Good
Thanks for
evening.
your patience.
No, yeah, of course. No, I mean, this is a good conversation. In terms of the ADU, I may have missed it, but the gist is ADUs can now be called condominiums, correct? Yeah, okay. So say that there's a garage or someone built something in the back, 200, 300, 400 square feet. So now that can be seen as a separate property, and the existing homeowner, right? So say that this is a single home lot. The existing homeowner can now sell his or her garage, their in-law unit in the back, and they're not landlords. They're just now neighbors to the people they sold it to. Is that basically the way it's going to work?
Yes.
Okay. And does accepting this, I wonder if there's a set or a package of policies or laws or something that is going to allow these new neighbors to coexist in a way. I know that now that there's pavement that can go around the ADU and stuff like that, but now, I mean, I don't know, it's just a lot, right? Like, you just sold your backyard. Now, who has rights to the rose bushes and trimming the flowers, and whose kids are going to play there? And there's a water slide, and, well, I don't know, like, did you buy that side of the backyard? I mean, so we accept this, but are we opening Pandora's box? Is there something that's going to accompany this approval if we approve?
And I'm sure staff will have a more detailed answer, but I just want to say my understanding is that wouldn't be a lot split. It would basically be like a homeowners association set up like it would with a typical condominium. So that association that's established would be in charge of all those issues you're talking about.
Okay, so that further confuses me, because now, so I'm on one side of the street and I sell my garage or backyard home, and then someone in the neighborhood sells theirs. Now they become, like, these two ADUs are now a homeowners association? Like, I don't understand that piece. Or only in homeowners associations do they get allowed to sell their ADUs and turn them into condominiums?
So both units would actually, both the primary dwelling and the ADU would become two condominiums in a homeowners association that is consistent of those two condominiums. So they would be required under state condominium law, essentially, to set up an HOA. That's the two owners, right? The primary dwelling and the ADU. And the HOA would have to have governance documents that actually do set forth all of those things, right? If it was an attached ADU, for example, they share a roof, it would have to explain whose responsibility is it to fix the roof if it breaks. It would have to lay out who has rights to access which parts of the property. So they would be, under the Davis-Sterling Act, actually required to set up an HOA with both units, both the primary dwelling and the ADU that's sold, as the two parties of the HOA.
Okay, interesting. So the lot, the single family home that I'm thinking about has now become in a small HOA, right? Obviously not a whole
Correct.
Community or a whole development. It's just,
It's
okay.
like a two-unit HOA.
Is there, I understand that we would be the first city, but across the country, has someone else set this up, and how's it going for them? Like, is there any disputes? Is there anything that we should be aware of?
So we do have other references in the city of Austin, Seattle, and those are some of the cities that have already adopted the ADU condominiums. And the approach that they have is very different from our approach, in the sense that it's mostly a legal document that is created. There aren't as many planning or other design considerations. And most of our regulations, even in California with the state law, there are very stringent requirements to create an association of this nature, which includes the HOA regulations creating of the CCNRs. And there is also about the utilities, who's going to pay, how are they going to maintain. So all of these guidelines, I think, are pretty robust to help create those 2 units. And I think Austin already does that as a routine change in terms of the ownership patterns.
Okay. And this is only for sale. So say that there's an ongoing rental agreement with somebody living in an ADU. This proposal it doesn't change their relationship, the definition as it currently stands. This is just if a sale wants to be made of the ADU. Is that accurate?
So the renter also has the potential to be a new owner as well. So it could lead to a new ownership either with the existing renter or somebody new.
What would trigger that? Is that something where a renter, once they hit 10 years, now become eligible to buy the property? I mean, so what are you referring to?
I think the conditions of contract between the two, in terms of the lease agreements, I think it's between the property owner and the renter.
So I think we're just saying essentially there's now an opportunity where the who was a landlord could sell to a renter, but there is no requirement for any such thing. We're just noting that that does create that opportunity. But no, it wouldn't, you know, it's no different than if you're selling a single family home that you already have a tenant in, right? It's the same thing, you know. If you say had a tenant in your ADU and you wanted to sell it, you know, you have to see, are you able to do, you know, what does your lease say with the tenant, right? The lease may not have any out provisions and you have to let them write out the lease. Or maybe you have something in the lease that says if the owner wants to sell, you know, you may have to vacate in a certain days. It really comes down to how that tenant's lease was set up. If someone wanted to sell off an ADU that is already occupied. I'll note we do think from having talked to stakeholders that we're going to see this more in new construction than people converting existing ADUs is what we're suspecting. We'll see. But based on the feedback we've gotten, we think that's going to be the more popular option, is to build a home with an ADU attached and sell them both fresh.
So the developer would sell both units. Okay. And does this, I know this has been proposed in the Berryessa neighborhood and a couple of neighborhoods across San Jose, but these small home communities, would those be considered ADUs and now would be considered small condominiums? Or ADUs has to have like a primary home in order for the ADU to even be defined as an ADU. Like an ADU just can't be an ADU on a single lot. Like it has to have something existing and then the ADU is an addition. So are we looking at a possibility of a community of now condominiums being developed across the city where like it's no longer like these small home communities, but now it's small condominium communities?
No, this is restricted to ADUs where there's primary dwelling with ADU. And we do have, I think, given the way you can do ADUs, I think the most you could get to is 4 condos potentially. Because in theory, if you had a duplex, you could have 3 ADUs on a duplex property. I don't know that we have that anywhere in San Jose, but in theory, under state law, you could. So you could get to 4 that way by selling the 3 ADUs in a duplex unit, but no, it would not allow anything like that. It really is, it's ADUs. So the first thing, these units have to be permitted as ADUs, which means there does need to be a primary dwelling and they have to follow all the ADU laws.
Okay, no, well, thank you. I think that concludes all my questions. I'm just, with any innovation like AI, right? You know, it promises all these new efficiencies and all these new cutting edge possibilities. And I think with this is also a very innovative proposal and step forward. But at the same time, I do hope and and I know staff, you work hard on this. Obviously, you do your research, but I would look towards the future to see what kind of hiccups, challenges, roadblocks may happen, and what can we do preemptively to avoid HOA disputes, HOA like litigations, neighbor to neighbor, declining quality of life, all that stuff. Like, what can we do to help a very highly motivated, a very interested homeowner to do this, but give them the details at the beginning, like full disclosure. Please read this, please know this, please look out for this, just so this doesn't come back as once, here today, innovative, but later down the road, something that, like a disaster just got out of hand. So, thank you.
Commissioner Rosario and then Commissioner Tordios.
Sure. So I had a question about each of them. One was with Commissioner Tordios said that if we don't amend and we just expect council, or what was it? If we don't amend and approve it as recommended by staff, then there will still be discussion between staff and Lucid Motors. What would be the reason behind Commissioner Oliverio's suggestion then?
Yeah, I mean, it would put it on record that the Planning Commission for sure says that we should have this conversation. As I said, I anticipate we will anyway, because I anticipate they will bring this up to council, and we'll get looped in on that. That said, maybe it wouldn't happen. It's possible. So the commission would be very clear that this is the commission's direction, and council would hear that as well. So that's another value is the commission's telling council kind of what you wanted, right?
Okay. Then I will likely be supporting Commissioner Oliverio's suggestion, having worked for a similar electric car company around the time Lucid changed its name after a TIWA. My question is, and then with the ADUs, my question is whether or not the changes are more restrictive than the Davis-Sterling Act for any reason, or if they're as permissive as they can be, including the creation of CC&Rs and whatnot.
The ADU condominiums are required to conform to the Act, so they are not necessarily more restrictive. They have to just comply with all of the restrictions that are already in the Act.
But there aren't any additional requirements that we're placing on
So we are fairly consistent with the state law. AB 1033 lays out all of the requirements, and we are proceeding with the same requirements as state law at this point.
I will note that there are a couple areas where we are requiring that they actually show us that the government documents do include the provisions for maintenance where there are shared facilities. We don't have to require that, right? We don't have to look at it, but we do have in our ordinance that is something that they would need to submit to us so we can look and see that that's in there. So that is an area where, based on these concerns, right, we have these kind of same concerns. Are we creating a situation where we're going to have kind of, it's new, right? Are we going to have owners who aren't getting along and who maintains what? So one thing we did look to is our condominium conversion ordinance. We do have an old ordinance on the books around condominium conversions that does include some additional requirements, and I think the one that we did keep in there was that requirement that they actually include some of those financials in their governance documents and send those to us so that we can have those on file and ensure that that is in there.
Okay, thank you.
Commissioner Tordios.
Thank you. Just briefly to Commissioner Barosio's point, I have no doubt that if we move forward with this ordinance, that this will result in some new disputes between neighbors. I just don't really view them as any different than the existing disputes that already happen throughout the city between members of HOAs and members of neighborhoods. To me, this is really just about lifting restrictions and allowing for a new housing topology to be on the for sale market in the city of San Jose. And then to the question of, are there other cities that have tried this before? I know staff mentioned Seattle, and I was looking at the data for this earlier today in preparation for this meeting. And in 2021, fully 1/3 of new ADUs that were built in Seattle were permitted as condos for separate sale. So to me, that means that this is actually a tool that could result in some new housing production and some new lower cost housing options for folks.
Vice Chair O'Neill-Wise.
Just to follow up on that, but it seems like the California law, the way it's written, is a lot more restrictive than maybe in Seattle and these other places. So just based on the way it's written already, there's already like a lot of hindrance to even, make it easy for homeowners to want to do it. And then there's the cost involved with all the legally and whatever, all the requirements. It would be interesting to have maybe some post-approval monitoring, maybe like, after 2 years, review the success rate and really review the data of like what has really been successful, what hasn't worked, to review the ordinance.
Commissioner Tordios, do you have additional comments?
Yeah, sorry, just to piggyback off of that. Quick question for staff. I know we already get reports on an annual basis about production of ADUs. Is it safe to assume that moving forward, that will also include a breakdown of any ADUs that are, permitted as condos?
Yeah, I don't see why we wouldn't include those in the reports. I mean, it'll be in that same database, so yes.
Amazing, thank you.
Commissioner Bickford.
Is there any provision here for removal or closure of this if the person wants to sell the ADU and the property owner wants to buy it back? Is that just another standard real estate transaction, or is there any provision here that talks about that? Or is it just another standard real estate transaction? And do we then roll the properties back together, or do we keep them separate?
So I've actually never had anyone ask to unsubdivide a condominium. So I don't know what the process for that would be. I think it wouldn't be something that would be compelled. I mean, I think what would happen is if the original owner wanted to buy the ADU back, they would buy it back and then they would just own both condominium units. In theory, they could probably then come to us and ask to re-subdivide it back to a single-family home if they wanted to, but it's not something that would happen automatically. They would have to ask us, and I think we'd probably have to go through another subdivision process of some sort to officially combine them back in and make them one legal unit where the second one can't be sold. But that would really be only upon their request. I think most likely in that situation, people would just own both condos.
So no limitation on doing that as a result of this, just...
Yeah, I mean, if they wanted to buy it back, the city wouldn't be involved in that. They could, attempt to buy it back.
Commissioner Borosio.
And along those lines of buying it back, it would just have to be where the person in the condominium in the ADU would just have to be open to it at that point, right? It's not, hey, I want it back, and they're like, oh, okay, yeah, just give me 2 months to sell it to you. It's sort of like now they're the homeowner as well, and they may say no, and they may live there for generations. Is that pretty much accurate?
Yes, that's correct. I mean, once it's sold, and you don't own it unless there would be something in your sale contract that has a buyback provision. But generally speaking, it's a different unit that's owned by someone else, just like any other condominium.
Okay. So you mentioned the buyback provision. That would sort of be in the HOA agreement, right? Some sort of language of 20 years from now, 15, every 10 years, we'll discuss buyback options or something. Is that sort of where that sort of language may exist?
Yeah, I don't know enough. I'm not a lawyer, so I don't know if it would literally go in that document, but it would have to be some sort of a private contract between them, whether it be in the HOA governing documents or a separate private contract that says, this is our provisions around buyback. But that's something they would have to negotiate and create a contract between themselves for.
Right, right. Okay, so my only recommendation is when the website is built out in the sanjose.gov website and as the brochures are made, please specify that there is, unless stated through another contract, all sales are final. And I think having that disclosed at the beginning would make the original homeowner of the entire lot or the properties understand what they're getting themselves into. That's my recommendation. Thank you.
I don't see any other hands up, so looks like we're moving towards voting. I just want to summarize for folks where we are right now. So Commissioner Oliverio had a motion which was seconded by Commissioner Cantrell.
Chair, point of order. I just wanted to get the opinion from the attorney.
Oh, yeah, of
Sorry
course.
to interrupt.
So yeah, Commissioner Young asked if we could consider the
Yeah, well, so what
sales
we'd have to
separately.
do first, if you wanted to segment out that one subdivision and vote on it separately, you'd withdraw your motion, the substitute motion, so that we would be then voting on a new motion, or you could, there could be another substitute motion, basically. We could do either way. I think we should vote on
So you think we should?
sorry, 1, 2, A through F without B, right? You just vote on 2B separately. So the first, there would be a motion to vote on 1 and 2, A through F with the exception of B. Take that vote and then vote separately on 2B. Is that what you had in mind?
Exactly.
Yeah, so segmentation usually happens when there's a conflict of interest, but just here, I think there's no harm in doing it since these are all separate items, code amendments. I think there's, otherwise, I think usually we wouldn't do something like that, but as a courtesy, I think it makes sense to do it here.
Okay, so just to be clear, can I withdraw my substitute motion and make a new motion in?
Yes.
Sure,
line with
or
what
you don't
said?
need to withdraw the substitute motion to make a new substitute motion, that's fine.
Okay, so I'll make a substitute motion that, you can help me if I don't say this correctly, that we vote on the staff recommendations other than item A2.
2A,
Two-
2B.
Other than item 2B, and then take a separate vote on item 2B.
And the
Two different
recommendation
motions.
would be to approve staff's recommendation for items 1, 2, A through F, with the exception of 2B.
Yes, correct.
Second.
Okay, does everybody understand?
No, so the motion, so first you've withdrawn the other motion, correct?
Either way, we're still voting on the
Because we're
substitute.
stuck right now. If you have a substitute motion, that's where we are. So the maker of the substitute motion needs to withdraw.
Or there can be another substitute
Right.
motion.
And then at that point, they'd make a new substitute motion.
Yeah, either way, we're voting on
Right,
the
but we got
substitute
to do
motion.
that.
You think he needs to withdraw the substitute
That's
motion
right.
instead of having the second motion? Okay.
That's right.
So you want to withdraw the second motion, or your substitute motion?
So,
I think, sure. This is just form. I mean, if you want to withdraw your substitute motion, I don't think he needs to do that.
All right, as a chair ruling, I'll say for simplicity's sake, let's just have one substitute motion. So if you could please withdraw your original and then make the new one.
sure. So I'll withdraw my first substitute motion and make a second substitute motion subject to the language that I said earlier in conjunction with what our attorney recommends.
Okay. And do we have a second for that?
Second.
Okay. So, Commissioner Young has made a motion that we, basically to approve the bulk of the staff recommendation, excluding the auto sales component, and then we'll have a separate discussion consideration on that. It's seconded by Commissioner Tordios. So, just to clarify, if that motion passes, then we'll have adopted everything except the auto sales, and then we'll just have a discussion on that. If the motion fails, we'll go back to Commissioner Oliverio's motion, which is to adopt the entire staff recommendation with an included recommendation that staff continue to discuss with Lucid and explore a framework for allowing outdoor sales downtown. So is everyone clear what we're voting on? No? Okay.
Chair?
Yeah.
The motion on the floor at this point is a substitute motion
Yes.
to approve everything in that agenda item minus item B.
Yes,
And
that's
then there will
correct.
be a separate motion and potentially discussion on item B.
Yeah. Okay. Thank you, Commissioner Alvario. So let's have our vote now. Vice Chair Nellis Wise,
Yes.
Commissioner Borosio,
Yes.
Commissioner Bickford,
Yes.
Commissioner Cantrell,
Yes.
Commissioner Casey,
Yes.
Commissioner Garcia,
No.
Commissioner Alvario,
Yes.
Commissioner Rosario,
Yes.
Commissioner Tordios,
Yes.
Commissioner Young,
Yes?
and myself, yes. So that's 10 yes, 1 no. So the substitute motion passes, which means we have adopted a recommendation of everything in the staff recommendation except for the auto sales component. So now we will discuss solely that. We don't have any motions on the table right now. So up to you. Commissioner Alvario.
I'd like to make a motion to approve the omitted item, item B, and to approve that. However, the intent is for staff to have a conversation with the interested party and to have those discussions prior to City Council.
Second.
Okay. Motion from Commissioner Alvario, second from Commissioner Casey. I saw Commissioner Rosario, you had your hand up?
No, just a second.
Okay. All right. Do we want to have any further discussion, or should we vote on Commissioner Alvario's motion? All right. Everyone's ready to vote. Vice Chair Nellis Wise,
Yes.
Commissioner Borosio,
Yes.
Commissioner Bickford,
Yes.
Commissioner Cantrell,
Yes.
Commissioner Casey,
Yes.
Commissioner Garcia,
Yes.
Commissioner Oliverio,
Yes.
Commissioner Rosario,
Yes.
Commissioner Tordios,
No.
Commissioner Young.
No?
Myself, yes. So that is 9 in favor and 2 opposed, so the motion passes. All right. Continuing on, item B is PP 23-008, which is a number of code changes relating to the municipal regional stormwater permit.
Well, good evening. My name is Reggie Nair. I'm Deputy Director. I oversee the Watershed Protection Division within Environmental Services Department. And let's see, I'll go to the next one. So for today's presentation, our goal is to provide you a brief overview with regards to 2 specific provisions within the stormwater permit that became in effect as of July 1st, 2022. These 2 provisions are listed there as C3, which focuses on new and redevelopment, and then also C6, which is focused on construction site control. And these are particularly related to specific city ordinances and policies that we have to update with regards to regulatory compliance. Towards the end of the presentation, I'll summarize what the staff recommendations are, and then I did come here last year, so I have some data. So hopefully, if you do all remember your questions, we did record some of that, so last April. So I'm not sure if anyone is new to the commission, so I apologize, but I just want to give a quick recap as to just about our storm, sewer, and sanitary. They are 2 separate systems. The sanitary sewer system is a series of connected pipes that is treated at our regional wastewater facility, which eventually clean water is discharged into the bay. The difference with our storm sewer system, that's not quite the case. And so we have approximately 1,700 outfalls throughout the city, and that it directly discharges into our waterways without being treated. So the goal of the stormwater permit and also other regulatory permits that we have for our sanitary sewer system, the goal is to really prevent pollution. in our collection systems. Also, just a brief recap we shared last time is that the current health of our waterways for both Guadalupe River and Coyote Creek is in dire straits. And essentially, this is data that's been collected by the Water Board, and it's been approved by the EPA. And it's just essentially just a barometer of our health of our waterways. And this can be found publicly in mywaterway.epa.gov. So the left of the slide shows information about the Guadalupe River, which essentially shows sources of pollutants related to mercury, pesticides, and trash. And then on the right side of the slide, it shows about Coyote Creek, which is slightly different, that also results from pesticides, toxin, chemicals, and trash. So what we did share about some of the overall framework of the permit, essentially it does include 22 provisions, and 4 of those are brand new. And this is, again, it was effective as of July 1st. The one that's particularly of interest for the Planning Commission is C3. This was amended, and it actually became effective as of November 1st, 2023. And then we'll talk a little bit more about the C3. So just a brief overview of this provision, C3. Essentially, it's just focusing on the threshold changes that is required for any new or redevelopment projects. And again, there are various different types of projects listed here that are required to install green infrastructure. And essentially, the green infrastructure is a system that treats any stormwater runoff before it enters into our waterways. And an example of that is in the top right corner, which you're probably all familiar with. Just a brief summary of some of these project types. So for commercial, municipal, and multi-dwelling units, the past permit focused on 10,000 square feet of any disturbed impervious surface, and now what the new permit required is lowered that threshold to about 5,000. In addition to the 5,000 square feet, that also will include any right-of-way or sidewalk improvements. So definitely more stringent. Single-family homes, they were exempted in the last permit. Now anything 10,000 square feet disturbance or greater is required to include green infrastructure. Small projects was originally about 5,000, and that got reduced to 2,500 square feet. And this is essentially just, they're not installing green infrastructure per se, but they're just disconnecting downspouts to drain into the, to the yardways. The next one is roadway projects. Back in the last permit, maintenance projects were exempted. But now any roadway project that is 1 contiguous acre, in addition to utility trenching that is 8 feet wide or greater, is now required to install green infrastructure. And then lastly, it's not listed on here, but there is a provision that we have to implement regional green infrastructure projects. And for the city of San Jose, we're required to install 5 acres. And we're going to meet that requirement. What I presented last commission meeting, we were in the process of implementing a regional project called the River Oaks. The name's revised to the Riverview Stormwater Garden Project. So I'll provide some information about the current status. Okay, and then another recap of the plethora of ordinance changes that we did have to change with regards to the new stormwater permit. This, for the commission, we did present about Title 20 changes, all related to what I showed in the previous slide, but in addition, we did go to council to amend some of Title 5 and Title 15 as well. And then just, this is not necessarily for this commission, but just to kind of give you a perspective of one of the titles that was a major win in our world. And particularly for the city. So as I shared, that C3, the amended version, was approved November 1st, 2023. And one of the things that I wanted to highlight, which was commendable with staff in collaboration with Planning, Building Code Enforcement, also Office of Economic Development, emergency interim housing. They're currently now exempted, and which was a huge win for us and you know, for all, not only just the city of San Jose, but a lot of the Bay Area permittees that are required to have this permit. And the 3 projects, just for reference, we wanted to just highlight to the commission. Those 3 projects listed there, Evans Lane, Monterey Burnell, and Rue Ferrari, these were under the previous permit, and they were required to install green infrastructure. So as you can imagine, now that this is exempted, we can build more, given that it can minimize a lot of the environmental impacts. So some additional updates that we do need to do for this next, for Planning Commission's review and approval is just to include the utility trenching, which is the 8 feet wide requirement. And then also we had an outdated reference to a guidance document embedded in one of the Muni codes, and so we wanted to change that so that we can separate that as a policy, because these will constantly be changing and it makes more sense to put it in a policy format. Also, this slide just shows just a summary of some of the existing policies, 629, that needs to be amended to address more details about the amended C3. And then in replacement for the obsolete guidance document that I mentioned in the previous slide, we're recommending adopting this new Council Policy 637, and this is entailing the projects disturbing less than 1 acre and best management practices for developers. So in conclusion, staff is recommending for the Planning Commission's approval and ordinance changes associated with Title 20. We will be going to Council to provide additional changes with Title 5 and 15. And not shown on this specific slide is some new policies and amendments associated with the administrative citation schedule of fines. And as I shared, these were, what you see on these slides were inquiries from the last year's Planning Commission, and so we do have some data that we wanted to just provide in some additional details, just to add a little more clarity as to what this all entails, you know, for the commission. So the first inquiry that was requested is is the total number of regulated projects impacted by the new permit, municipal regional permit. And so based on staff's analysis, starting July 1st, 2023, to where we are today in, or actually from April, the data that we found was out of 120 projects that complied under this provision, about 15%, so the 18 that you see in the dark purple, is essentially what is not required to install green infrastructure in the last permit, but in this permit is required. So, which, you know, you can start to see an increase. 15 of the 120 were not required. They were not considered regulated projects. And the difference between the 45 and the 42, I mentioned to you that in this new permit, we are now required to include sidewalks and any public right-of-way. That 42 is showing the new permit requirements. So, but either way, they're both required to comply to the municipal, to either the last permit or this permit. So hopefully that was clear. But a lot of nuances associated with that. But another inquiry that the commission raised was just examples of what are low impact development and non-low impact development. So what you see here is the low impact development treatment measures, and these are essentially engineered devices that have mechanical features that mimic the natural way of treating water, for water quality purposes. And so what you see on the left is media filters. Those are like kind of the mechanical ways of treating the water. And on the right are these essentially 4-story buildings that are built underground to collect trash that enters into our storm sewer system. We as a city, we have over 30, I think 32 to date. And so we're one of the largest cities, or one of the cities that have the largest amount of these large trash captures to comply. Another element of this is the low impact development devices. These are actually various forms of bioretention that are natural, that allows the treatment of water before it enters into either infiltrates into our groundwater system or into our storm drains. The third inquiry that the commission asked more details about is what I mentioned, that used to be called the River Oaks Project and is now the Riverview Stormwater Garden Project breakdown. And this is almost going to be completed. It's estimated to be done in September. And if you want to look at that QR code, there's some information. It's quite an exciting project. This is the first regional project in Santa Clara County, and so it's definitely quite a feat. And again, this was in partnership with many departments. Public Works has been leading this effort. And the last one was essentially a question about outreach resources, given that we lowered this threshold and might open up opportunities for other types of developers that may be involved in, that may be required to comply with this. And so we have done a concerted effort, again, in partnership with Planning, Building, Code Enforcement, and Public Works, to really offer more varieties of language, and it's not all translated, but an example of this Riverview Stormwater Garden, you can see we did translate that in Spanish and Vietnamese for the community as an education outreach. But on demand, if there's anything additional, we'll definitely provide. So that concludes my presentation, and I really thank you for the opportunity. So,
thank you for that presentation. I'll recognize Commissioner Cantrell.
Okay, great. That was much better. Thank you. I remember last time I had a lot of concerns. That was very helpful. I'd still have some small concerns, but I think you might have answers to. In those calculations of impacted projects, how many might be homes?
Currently, to date, we don't have any homes. So
because that's a pretty big lot.
Right,
yeah.
right. So
okay.
Currently, no homes yet.
So even the small projects, do you know how those would be primarily the projects that would include homes, correct?
I don't know the specific details of, they're not single-family homes. I mean, there'll be multi-dwelling units.
Okay.
Yeah, so that's considered home.
Okay.
So, yeah.
Well, no, I was
right.
actually saying,
yeah, sorry.
I was thinking single family.
I was thinking a single-family home.
Okay, actually, I was thinking single
Oh,
family.
okay.
All right. Well, great. So that answers my other questions then. Thank you.
Commissioner Young?
Thank you, Chair. Thank you for your presentation, and especially for getting back to us on the questions that we asked for. A lot of times we forget what questions we ask, so kudos to you for bringing that back. I really appreciate it.
I'm going to kudos my staff for reading, watching all the videos, so yes, thank you.
All joking aside, though, thank you.
Yeah.
The work that you all do is so important, and it's so under-recognized. I think it's one of the services that our city provides that flies under the radar, and probably most of our residents aren't aware of it, but it's so important, as you pointed out, with the quality, the health quality in the Guadalupe Creek and the Coyote Creek being not what we would like it to be, flowing into San Francisco Bay. So I just thank you for all the work you did. I'm going to make a motion that we approve the staff recommendation.
Motion from Commissioner Young and second from Commissioner Oliverio to approve the staff recommendation. Any further discussion?
I have
Vice
a
Chair
quick
Nellis
question.
Weiss.
Yeah, when you were showing the slide on the recap C3, and you talked about single-family homes being exempt, something about the 10,000 square foot.
That was in the previous permit. Now they're
Oh.
not.
Okay.
So any single-family home that disturbs 10,000 square feet or greater is required to implement green infrastructure.
So does that include the footprint of the house? Or
No,
no.
no,
Okay.
it's just anywhere they disturb.
Hardscape.
Hardscape, yeah. Or any earthscape to implement hardscape. Does that make sense?
Yeah.
Okay.
Yeah. Okay, thanks.
Commissioner Cantrell?
Yeah, can't miss the opportunity. I'm sorry. I love bioswales. I think they should be in many places as possible. But is there a possibility that this will become more restrictive? And if so, I would assume we'd have some sort of subsidy program for homeowners to kind of reduce the impact and increase the impact on the environment at the same time.
To your first part, 4.0 is about to start conversations, so more to come. With regards to subsidies, I think that's a bigger conversation as to how that could be managed.
We'll have it then. Thank
so more to come.
Okay.
Vice Chair Nellis Weiss?
I also have to take the opportunity that I have right now. You mentioned that there was some concern of the health of the Guadalupe River and the Coyote Creek. I live fairly close to the Coyote Creek. There's some irregular fires there of the trees, and of course, because I love the environment, I'm concerned about the wildlife and whatnot. So what are you all doing to really focus on improving the health of those two rivers?
I guess I can go back to, if you go back to the slide that shows the different provisions, so that is covered under provision C10, and that has some specific requirements to address the condition of the waterways in detail. So that's something that we've been working very closely with the Water Board.
Commissioner Oliverio?
Thank you. Just one question. On the building a new road that's over, was it 1 acre? So even though like Cambrian Plaza was approved a long time ago, when they take out their actual permits, because they're going to build more than 1 acre of road, then they will implement these policies.
They'll have to implement the green
Thank you.
infrastructure, yeah.
All right. If there's no further discussion, we'll have a vote on Commissioner Young's motion to approve the staff recommendation. Vice Chair Nellis Weiss?
Approved, yes.
Commissioner Borosio?
Yes.
Bickford?
Yes.
Cantrell?
Yes.
Casey?
Yes.
Garcia?
Yes.
Oliverio?
Yes.
Rosario?
Yes.
Tordios?
Yes.
Young?
Yes.
And myself, yes. That passes unanimously. Okay. Moving on to item C, PP 24-004. This is municipal code updates concerning emergency residential shelters.
Good evening, Chair and Planning Commissioners. My name is Christine Doe, and I am the project manager for this proposed ordinance update, file number PP 24-004. And joined with me this evening are Michelle Flores, Supervising Planner, and Jared Ferguson, Principal Planner. This presentation is on the proposed ordinance updates to Title 20 of the city's municipal code as they relate to emergency residential shelters. I'll begin with a brief background on the proposed zoning code updates. So the updates would amend the definition of emergency residential shelters to reference Government Code Section 65583, in which the state expands the use of emergency residential shelters to also include interim interventions. The updates would also permit emergency residential shelters by right in at least one zoning district that also allows for residential. And these updates are necessary to comply with our 6-cycle housing element recommendations and to comply with state law. So going a bit more in depth with strategy H14 of the city's housing element, the housing element law requires the identification of one or more zoning districts where emergency residential shelters are allowed by right, and it also requires the city to have enough bed capacity within these shelters to meet the needs of the city's unhoused residents. So to comply with housing element law, the combined industrial commercial zoning district was modified to allow emergency residential shelters with 50 beds or fewer by right, and shelters with more than 50 beds could have been permitted through a use permit. So in this zoning district, it would have been through a conditional use permit. And the city's 6-cycle housing element used the 2019 point-in-time count, also known as the PIT count, since the counts were not conducted during the pandemic. So in 2019, the PIT count documented 6,097 individuals experiencing homelessness. So that resulted in a deficit of 1,647 beds, as at the time the city had a capacity of 4,450 beds in the combined industrial commercial zoning district. So to address this, so in 2023, the PIT count was conducted and it documented 6,266 individuals experiencing homelessness. So that increased the city's deficit to 1,816 shelter beds. So to address this new deficit, strategy H14 outlines a program to update the zoning code to increase the emergency residential shelter bed capacity and to comply with Assembly Bill 2339. And so Assembly Bill 2339, which was passed in 2022, revises housing element law to require the identification of one or more zoning districts that allow for residential uses, and that includes mixed use, where emergency residential shelters would be permitted by right. And because the city did not meet its capacity needs for its unhoused residents as part of the analysis done for the 6-cycle housing element, the city has a statutory deadline of 1 year post-housing element adoption to comply. So currently, within the combined industrial commercial zoning district, we do not have enough adequate capacity, and it also does not allow for residential uses. So this is why the city needs to identify zoning districts that allow for residential uses to close that deficit of 1,816 beds. So the zoning districts that staff has identified already allow for emergency residential shelters through a use permit. So these zoning code updates are focused on providing a pathway for that ministerial approval process. It's also important to note that the city has declared a shelter crisis, which suspends state and local laws, including zoning and land use. So these provisions are applicable to shelters located in new or existing buildings or structures owned, operated, or constructed for or on behalf of the city of San Jose on land owned or leased by the city of San Jose. So to clarify, any emergency residential shelters that are developed under the Shelter Crisis Act are not subject to the zoning code updates proposed in this recommendation. And through the Shelter Crisis Act, the city currently operates 6 interim housing communities, 3 of which were just mentioned in the previous presentation. And the city is also involved with many other shelters throughout the city. So these are some examples of those communities and shelters. Rue Ferrari and Guadalupe are both interim housing communities that the city jointly operates, and the Bacardo Reception Center is operated by Home First, which receives grant funding from the city. So again, the majority of emergency residential shelters operating in the city were developed under the Shelter Crisis Act, and those are not within the scope of this work. These updates would apply to privately operated emergency residential shelters that are required to follow state and local laws, including zoning and land use, and so they would need to go through the planning and permitting process. Going into the zoning code updates, staff is proposing an update to the existing definition of emergency residential shelter to reference Government Code Section 65583, which specifies that emergency residential shelters include other interim intervention, including but not limited to navigation centers, bridge housing, and respite or recuperative care. For the definition, staff is also proposing some minor text amendments to follow best practices for technical language, specifically using people first language. Staff is also proposing the allowance of emergency residential shelters with 100 beds or fewer by right through a ministerial approval process in zoning districts that already allow for them through a use permitting process. So those are the commercial pedestrian, commercial neighborhood, commercial general, public quasi-public, urban village, mixed-use neighborhood, and mixed-use commercial zoning districts. And the ministerial approval process would apply to sites that are outside of the airport influence area. Staff does plan to continue this work to further update the definition, expanding the physical form that an emergency residential shelter can take. Currently, the zoning code defines a shelter as a singular building, but through a lot of our outreach and research, staff found that there is a shift toward non-congregate shelter, which can take on the form of a structure, a series of structures or buildings, tiny homes, prefab, stacked modular buildings, etc. And staff also plans to further update the objective standards within the zoning code to ensure it is housing first and low barrier to entry. We also plan to add downtown commercial to the list of identified zoning districts and take all sites within the airport influence area to the Airport Land Use Commission so that the ministerial approval process would be applicable to all sites. And as part of this work, staff conducted outreach meetings throughout March and April. Staff met with the Homeless Response Division of the Housing Department, operators such as Home First and Life Moves, as well as Destination Home. Staff also conducted a virtual community meeting on April 11th where 5 community members attended. There was a general understanding that this work was being done to comply with state law, but there were also some concerns about over-concentration and lack of oversight and maintenance for these private shelters. One community member expressed interest in seeing these shelters operated by the city, whereas staff then explained that those shelters would then fall under the processes and procedures of the Shelter Crisis Act. So that would not be within the scope of this work specifically. Staff also noted that many of the shelters that are currently operating in San Jose are not privately operated due to various factors, but mainly financial infeasibility. The majority of shelters do receive some sort of funding from the city or the county, and other community members expressed concern about the city bearing the burden of other cities' unhoused residents, where staff clarified that each city does conduct its own point-in-time count and would need to address their unsheltered capacity within their respective housing elements. So each city is required to do this work to accommodate for their residents. Moving on to CEQA, this is not a project. It falls within general procedure and policymaking, resulting in no changes to the physical environment, since shelters are already permitted in the identified zoning districts, and those going through the ministerial approval process would be subject to the development standards that are already codified within our zoning code. And for timeline on next steps, this item will be heard by City Council on June 11th. In the meantime, staff will continue working on the additional zoning code updates previously mentioned, with the goal of coming back to Planning Commission at the end of this calendar year. So staff recommends Planning Commission to recommend that City Council take the following action: adopt an ordinance amending various sections of Title 20 of the San Jose Municipal Code to amend the definition of emergency residential shelters, amend the allowed use of emergency residential shelters through use permit and by right in the identified zoning districts, and the amendments to allow a streamlined ministerial approval process for emergency residential shelters. Thank you. That concludes this presentation, and staff is available for questions.
And this would be the time for public comment, but the chambers are empty, so we'll go to the commission. Cantrell, Bickford, Oliverio, Tordios.
So with these changes, how many more congregate shelters would we expect, and how many beds would that represent? And that's only congregate.
So just first, they're looking up the number. So what we've done is a calculation on capacity made available through the zoning. So it's not necessarily a prediction of exactly when or where shelters would open, but where there is capacity to allow the shelters by right. So we have the number of beds that would result on those sites that we're rezoning. So we'll pull that number up, but just to provide some context to your question too.
So with the vacant sites analysis that we did, we would have a capacity of 1,900 beds when the current PIC count is 1,816.
Congregate? I'm congregate, really?
So currently with our definition, it only allows for congregate shelters. So what we're doing as part of phase 2 is expanding the definition so that we could allow non-congregate.
Okay, I'm confused now. I think I like what you're saying, but I'm not sure I understand it.
So the existing definition for emergency residential shelters in our zoning code specifies that it is a singular building. And so right now we are amending the definition to reference Assembly Bill 2339 so that we are in compliance with the state's expansion of what is considered an emergency residential shelter. But in the next phase of our work, we are trying to be very much housing first and low barrier to entry, and so we would like to expand that definition to then include structures, series of structures or buildings.
Okay, thank you. Okay.
Commissioner Bickford.
Yeah, I know what I'm doing. I have a question about the volume of, not sure how to ask the question, land, property. I'm looking at commercial pedestrian zoning, commercial neighborhood zoning, commercial general zoning, public and quasi-public zoning, urban village and mixed-use zoning. Exactly how much of the city is zoned in these ways that we are saying that you can either by permit or by right? I mean, it feels like I know I know what the properties around me are zoned, and it feels like almost everything that is not zoned residential is now available for housing. For emergency housing. Is that the right way to look at this?
I don't think we have the specific number of sites. I mean, we could get that for you, but I don't think we have that in front of us right now. But just to give some context, as staff was explaining in the presentation, so the sites that we are making this change to already allow emergency shelters through a use permit, and they also actually already allow or generally allow a low barrier navigation center by right. So the universe of sites is not so drastically changing. It's just how they are permitted. for the most part. So it's not a direct answer to your question, but maybe just to give you some context in terms of the
Thank you.
change.
That's the context I was looking for. It felt like this was a drastic change, and that's what I was trying to comprehend. Thank you.
Commissioner Oliverio.
Thank you. On AB 2339, do you have any understanding of what's the level of compliance across the state? Are we the first? Are we in the middle? Are we at the end?
We're kind of right in the middle. I think in this region it varies. Some cities may already have been in compliance. Some cities may have had a smaller deficit, so there are changes necessary to come in compliance or less. Some cities may not yet be in compliance because they're still working on getting an adopted housing or adopted and certified housing element. So it varies quite a bit. So.
And the 1 year to comply, that started when for San Jose?
June 20th is when the council adopted the housing element. So that's the deadline we're working against here.
Okay.
Yeah.
And then can you think of some cities locally that have already passed their compliance in Santa Clara County?
We are aware that Mountain View has recently was recently in compliance with this bill.
Okay, 1 out of 18 or something like that?
Yes.
Okay. And then it's 1 or more zoning districts. So, go on.
Correct.
Okay. And then, so I noticed a litany of districts, which I think is what the commissioner noted, seems like it's everywhere. So, could we have just done 1 additional? Or is staff going above and beyond what's being asked?
In some ways, we're going a little bit above, but also I would say, like I mentioned to Commissioner Bickford, the sites that we have allowed it on by right already allow a low barrier navigation center by right, and the law says that we have to treat low barrier navigation center the same as we treat emergency shelter. So I guess technically we could pick 1 zoning district, but we felt like it made sense to have it be matching of where we already had to allow low barrier, we allow low barrier navigation centers by right.
And when you're saying low barrier, are you talking about the types of structures that can be considered, or low barrier, the person can come in and continue to do drugs?
Low barrier in the people that will be allowed into the shelter, in terms of the requirements for them to be admitted.
Okay. So to give you an example, right down Santa Clara Street, when it turns in the Alameda, you just pass Whole Foods, there's the Arena Hotel, which is low barrier entry, and it's been very problematic for the whole community. I mean, it's, I'll just simply say that. It's been problematic. And the deep concern is that providing shelter and the person can really do whatever they want ends up having externalities which affects the business district. Vacancies in businesses, neighbors that are complaining, documented arson on one of the houses. So does AB 2339 specifically say it must be low barrier?
The bill states that emergency shelters under the provisions of Assembly Bill 2339 include interim interventions, and low barrier navigation is an interim interventions.
And is there discretion from the city to say, well, okay, we see how this bill is coming, but we would prefer to not be low barrier? I'm just curious our options.
Yeah, so AB 2339 limits the objective standards and criteria that we can review the emergency shelters for, and that is not a criteria. So we are limited to things like number of beds, length of stay, proximity to other shelters being 300 feet apart, security and lighting, but not being low barrier.
Right, so are you telling me that the state has tied the city's hands and it must accept low barrier, which for the members of the public is substance abuse, you know, in whatever they choose to do? There's no condition you must be sober for housing?
That is correct.
Okay. And then are there any of these that you find problematic, like PQP or any of these that you've suggested that you think are going to have more of a conflict with neighborhoods? Considering under this assembly bill, neighbors have zero voice to share their concern with elected officials. They have no, because there's no public hearing, there's no ability for neighbors to say, these are my concerns, this is my genuine feedback. So looking at the ones that you've chosen, which ones do you see as the most problematic or more likely to have conflict?
I mean, I think we feel comfortable with these districts. I mean, I think as we alluded to in the presentation, I mean, yeah, it's not required, but often the case that there is city funding involved, so there is generally influence in terms of operations. You know, that being said, I mean, these types have, low barrier navigation centers have been allowed in these districts. You know, that was a previous state law that passed that required us to allow it in these districts where mixed use is also permitted. We, you know, haven't had, you know, significant issues that I'm aware of, but I don't know if you have anything else you want to add. But.
Yeah, so through the exercise to meet our capacity, we looked at where we currently already allowed it. We do have a buffer of just over 100 to meet the pit count. And so we chose to increase it to 100. So after 100 beds, it is a use permit. So it still gives the community an opportunity to come through us. The other part is length of stay. So they're currently only limited to 60 days. If the operators would like the residents to stay for longer than 6 days, they also need a use permit. So that also would trigger a discretionary process where there could be community input. And since 2010, we've only had 2 sites that have gone through a use permit. So in the last 14 years, there have only been 2 entitlements through that use process.
Thank you. And you said could be a process. So I just want to be clear, is that would be or could? I mean, there's just a distinction of difference there.
Yeah, so if it's under 100 beds, then it's a ministerial process.
Right.
And then over 100, it is a discretionary permit. So use, conditional use or special use depending on the zoning district.
Right, so under 100, ministerial, no public hearing. 110, is the hearing required or optional?
Required.
Great, good to know. And then, and once again, these are private shelters, not necessarily a city shelter, or am I incorrect about that?
That is correct. So if they are have a lease with the city, then they would go under the emergency shelter crisis, so then that wouldn't fall under this process. So these would be ones that aren't receiving funding from the city or have a lease with the city.
So a private entity that wanted to open a congregate shelter within the zoning district without city funding could move through AB 2339. If they wanted city funding, then they would work with the emergency declaration?
Yeah, under the Shelter Crisis Act, those operations are not subject to local zoning or land use. So they don't. The city itself, in working with those partners, don't follow land use like the zoning or general plan designation.
And then we had a certain capacity with the zoning we have now, I think of 1,800. Like if we did nothing, there's capacity for 1,800, but that falls short, correct?
So through our vacant site analysis, we found that we have a capacity of 1,900. We are currently at a deficit of 1,816 beds.
Got it. So with the current zoning districts, we have capacity for 1,900.
Yes.
And then with these additional, I missed that number.
So originally we had 4,450 sites within the combined industrial commercial zoning district. And then we added these additional zoning districts to comply with state law because they allow for residential, and that provided us with an additional 1,900.
So give me the number of what we have today versus net new based on all these changes. Is it just 1,900 more through all these? I'm sensing it's a bigger number, but I don't see it.
Yeah, sorry. So there's the number of sites that are zoned in this way that would permit these shelters, and then we also, under the law, have to do a calculation of what could actually be deliver the bed capacity. And so we're relying on the vacant sites within those zoning districts to count that. And so that's where we're counting that 1,800 number to make up the deficit. So there's more sites potentially, but they're not vacant. They have uses on them
Of course.
and other things, right?
But all we have to do is prove capacity, right? So we are increasing our capacity, and I'm really unclear by adding, let me go back to my notes here, by adding 1, 2, 3, 4, 5, 6, 7, 8 zoning districts, what's our increased capacity? It's not 1,900, right? Because we have 1,900 today with just the zoning districts we have. So I'm curious, what's the delta of difference?
Well, so part of the calculation is that the beds that we can consider as part of our capacity need to be allowed by right.
Okay.
And so right now, because in these zoning districts, they require a use permit, they technically don't count as capacity.
Got it. So if you're telling me if all the proposals were under 100 units, then you could give me a number. But because some of them might be over 100, then you couldn't be able to kind of estimate what that number is.
I believe the current limit is 50, not 100, for whether you need a permit or not. Wouldn't this change it to 100?
I get the clarification.
Yes, that's right. So right now, where we allow it by right, there's a 50-bed limit. This increases the by right to 100, and then we're expanding the zoning districts.
Does AB 2339 state the 50 to 100?
No.
Okay.
It says that we can limit the number of beds.
So the city could choose to keep it at 50?
Yeah, but in this case, then we would be short in terms of the capacity, relying on vacant sites to meet that capacity.
And that's even with the expansion of these number of 1, 2, 3, 4, 5, 6, 7, 8 new districts.
Yeah, so if when we're doing the deficit calculation, if we use non-vacant sites, there's a lot more rigor in terms of what we have to show that the capacity could be used there, similar to the process in the housing element with our sites inventory, how if we use non-vacant sites, then we have to go through additional analysis. So in this situation, we're relying on the vacant sites to show the capacity of beds to meet the deficit.
Got it. So as you were doing your analysis and you said, hey, let's add some more zoning districts. Okay. And you said, well, let's add commercial pedestrian. Did someone say, okay, that nets us 190 more? And then let's add commercial neighborhood. Oh, that nets us 400 more. Was analysis done in that way to understand the capacity potential?
We didn't look at it in that way because kind of the other context that I was explaining. So since low barrier navigation centers are already allowed in those districts and under that state law, we have to treat low barrier navigation center the same as we treat emergency shelters. We feel it better to be consistent in our zoning because in theory, someone could say, I want to build a low barrier navigation center under the zoning, and that's already allowed by right. So we felt to be consistent, to be clear, it's better that we update emergency shelters by right in the same districts as low barrier navigation center because of that clarification in state law that they have to be treated the same and they are the same under a definition point of view.
Okay, thank you. Thank you for the presentation. Thank you for answering questions. And I'm still going to ask another question, which is repetitive, and I apologize. And perhaps it's me. With the current zoning district we have capacity for 1,900, correct?
So with CIC, the only one that has a permitted use currently, it was 4,450, and that's based off of vacant. So vacant land, it was 4,450.
And then with all these additional districts, do we know what that capacity is?
1,900 with the vacant sites that we found. So then that gets us over the PIC count of 6,266.
Okay. My apologies for asking all the questions. Thank you for the clarification. It really helps. I appreciate it. Thank you very much.
Commissioner Tordios.
Thank you. A few questions for staff. I know in the public outreach there were some shelter service providers who talked about, the financial strain of needing to go through the use permit process. I was curious if an operator did want to go to 150 rather than 100 here. Do we have a sense of how much additional time and cost that is kind of putting on the service provider to go through that process?
We can look up the cost of the permits we were going to check. So it depends if it's a SUP or CUP, there would be a cost associated with that. And then we did have time estimates on that. I think to be honest, we did have a conversation about what the right threshold was for number of beds. And I think, the team had some conversations and felt like 100 was a good balance between what we've typically seen in some of our recent non-congregate shelters and what might be a bit more of a kind of, maybe more of a congregate shelter model or something else that we felt like maybe is warranted to go through that process. But I think it was a balancing act. And so we did debate 150 or 100 if that was the appropriate number. So, yeah.
Yeah, and so for the cost, it's about $25,000 for the higher end for a CUP and approximately 7 months, maybe longer. They go through CEQA process with the use permit.
Thank you. Yeah, I saw the discourse in the staff memo about, deciding between 100 and 150. Saw that there was, some public comment concern about operations for the higher 150 limit. I also saw that, in the community meeting, only 5 people showed up. So I hope that we're not, over-indexing too much on that side of the public comment. I would personally love to see us continue to streamline this process, get larger shelters available via the by right process here. I was also curious if it might make sense. It looks like we're using that 100 unit threshold for both the CIC existing land use as well as these new residential zoned areas. Did staff consider potentially having a higher threshold for by right use for the CIC zoning versus the residential zoning?
We did, and again, going back to having outreach and being able to have community input, we kept it at 100, close to what we need to meet our capacity, but we're open to more, but still trying to balance that with that community outreach.
Thank you. Yeah, the final thing that I'll note here is I saw in the staff memo the mention that Life Moves was, looking at potentially redeveloping some of their own sites in the city to intensify the use, add some more beds. I had the opportunity recently to tour the San Mateo County Navigation Center operated by Life Moves, and it was clean, it was orderly, seemed to be, operated very well, and it was that sort of stacked modular design where you're able to get more units in a smaller amount of space. So anything that the city could do to enable that sort of development in the city, help us get some more capacity here, I would be in favor of it. Thank you.
I wanted to clarify something in the staff report. So on the issue of the length of stay, it noted that currently the limit is 60 days where you don't need a permit. Is that correct?
Yeah, so you do need a permit, but if they would like to stay longer than 60 days, then that needs to be added to the review of the use permit.
Gotcha.
Yeah.
Okay, and then and my understanding is while nothing's changing there currently, staff is interested in exploring extending that length.
That is correct.
Okay, great, thank you. Vice Chair Nellis-Wise.
Thank you. I wanted to share a story. Back when I just graduated UC Santa Barbara in 1999, my first job was working at a rape crisis center. And on 5th Street, where we are like right now, I volunteered at one of the only youth homeless shelters here in San Jose. It was an old Victorian house. It was moved because of the construction of City Hall. And it was really eye-opening, to see a lot of that. So I definitely care about the community and the youth and the families and the children and want to see them housed. So I thank you for all your work. I think it says a lot. I also care about neighborhood preservation and, making sure that whatever you put in is not highly concentrated in one district like District 7 or on the east side or, in just some of these areas. I don't have a map of where all these zoning is at. I just don't want it to be highly concentrated just in one area. So those are just my concerns. I would go ahead and recommend approval of this, make a motion to recommend this.
Motion from Vice Chair Nellis Wise to approve the staff recommendation and a second from Commissioner Cantrell. Any other comments? Vice Chair Nellis Wise specifically, any other comments?
My other comment was, if it's something that's permitted by right, then do you lose the ability to condition any part of it? Because of course, with some of the issues that some of my other colleagues brought up in regards to neighborhood nuisance, safety, how are you imposing any post-approval monitoring of this?
Yeah, so through the process, we decided to require a ministerial permit. So it would still need to come to staff for review. We can coordinate with our development review partners. And then we can also, in the permit, put conditions of approval. So we can put our standard permit conditions for like nuisance and like litter control and all of those.
Okay, good. Thank you.
Commissioner Tordios, did I see your hand go up? Okay. I just want to thank staff for doing this work. This is really important, and addressing our shelter capacity is a huge part of addressing the homelessness crisis here in San Jose. I also just want to say, looking forward past this to your future work, I really appreciate that there's a focus on making it easier to provide non-congregate shelter. I know anecdotally you hear from unhoused folks that congregate shelter is, can be a barrier to folks getting into shelter because, they're concerned about their personal safety or other related things like that. So I'm glad that that's a focus for the future work here. I see Commissioner Rosario put your hand up.
Sure, I was just going to say that it seems to me like the state is trending in that direction. It seems to me like the mayor is celebrating Senator Becker's SB 1395 being unanimously approved by the Senate, and this is going to continue in this direction. So I'm glad that you are taking steps to push us further.
I don't see any other hands up, so we'll go to, Commissioner Alverio.
Thank you, Chair. I'm going to vote no, but I want to document why. So one, I don't believe other cities are pulling their fair weight in our county or in the state of California. I have a real problem with by right. I think ultimately democracy allows you to have a public hearing in front of your elected representatives. So I prefer to have more public hearings than less. And knowing that we had discretion on what we did with 50 or 100 or the zoning districts, I would prefer a more narrow adoption of 2339 and then broaden it later if it felt the need to be. On outreach, I genuinely feel if you went to neighborhood associations, you'd probably get a higher turnout. But I know there's limits to, because everyone's always has their critiques on outreach. And then, the State Department that's making us do all these things, HCD, the legislative hearing this week, they are now going to audit HCD. And they're going to audit HCD because they have a lack of documentations. Their modeling, how they do their assumption, has errors. And they actually had no analysis of some of their assumptions. So when they designate X number of units to every city, they don't even have factual ways to say how they got to that conclusion. So I'm skeptical of this state overreach and local control. I think ultimately, I appreciate your work. You're just trying to do the compliance, right? You're trying to come up with best, and you have a variety of elected officials and interest groups and everything else that want certain things. So I appreciate all your hard work, and thank you very much.
All right, time for our vote. Vice Chair Nellis Wise.
Yes.
Commissioner Borosio.
I think we can do more homework on this, no.
I'm sorry, what was your vote?
I said no.
No. Okay, Commissioner Bickford?
No.
Commissioner Cantrell?
I like that you're observing more of the humanity of the people that we're trying to house by doing less congregate housing. I'm going to say yes.
Commissioner Casey?
No.
Commissioner Garcia?
No.
Commissioner Oliverio?
No.
Commissioner Rosario?
Yes.
Commissioner Tordios?
Yes.
Commissioner Young?
Yes.
And myself, yes. Robert, I think I lost track of the number.
Yes, Corosio, no. So 1, 2, 3, 4, 5. Yep.
Okay, thank you for clarifying that. So that's 6 yes, 5 no. This passes. All right. Anything for referrals from city council, boards, commissions, or other agendas?
Nope.
Okay, good and welfare. Do we have a report from city council?
Yes, we do.
Can you turn your mic on?
Yes, we do. Yesterday, the City Council approved 2 items related to land use. The first one has to do with amendments to various sections of Title 20 of the city's municipal code related to conversion of private parking, outdoor dining, and other outdoor uses associated with on-site businesses. The second one had to do with 511 parcels that were city-initiated conforming rezoning in compliance with Senate Bill 1333. That's it for the council report.
Thank you. Anything for subcommittee formation, reports, outstanding business?
None.
How about any updates to the commission calendar or study sessions?
Not at this time.
Anything for the public record? Okay. Well, with that, we will adjourn at 8:50 p.m. Thanks, everybody.